I am the co-chair of the University of Colorado Hospital Ethics Committee and am one of the people on the planning team for all of our Ethics Grand Rounds events. So I am going to be moderating today and am really honored to introduce our speakers this morning or this afternoon. The first person we will be hearing from about guardianship is going to be Katie Herrmann, who is the manager of our inpatient social work services here at University of Colorado Hospital. Then Emily McDonnell, who is also a social worker and the guardianship social worker. She will tell you about her role and her position. And then Sophia Alvarez, who is an attorney and executive director of the Colorado Office of Public Guardianship, the pilot program. And this is a really great and important topic, very present to us in many ways, and particularly in ethics, where we are constantly seeking in patient care to have shared decision-making. And there are so many permutations and difficulties with that at times in terms of how the patient's voice, as best as possible, or as most as we can discern it, is part of the decision-making process. So there are lots of different times and ways that we get at shared decision-making. And yet there is also one of those ways being guardianship. And this question about how about a guardian for a patient comes up not infrequently. And there are different efforts at addressing the ethical issues and options around that and operationalizing it. So with that, again, honored to introduce Katie, Emily, and Sophia. And so Katie, I will turn this over to you. Thank you so much.
All right, thank you, Julie, for that introduction. Hi, as Julie said, I'm Katie Herrmann, and today we're just going to talk a little bit about the objectives, what we hope that you all will take away from this presentation. The first objective is that we want to be able to identify the ethical issues that can be associated with guardianship, describe the process of guardianship in Colorado. It's important to note if we have folks from around the country, every state has some different statutes around guardianship. So this really, our focus today is the guardianship statutes in Colorado. The third objective is we're going to describe the resources available at the University of Colorado Hospital. And, oh, sorry, I'm sorry, I just messed up my screen. I'm gonna try to do this again. Shoot. Dave, I think I may need your help again. I apologize. Here we go, got it.
I'm watching you, you're doing okay.
All right, there we go. Sorry about that, folks.
It's okay.
Okay,
just use your arrow keys to.
Yeah. Actually, I'm trying to
put
just
it on
get
screen show. That right there, yes.
Okay, there we go. Sorry about that. All right, so, and the last one is describe, we'll have the Colorado Office of Public Guardianship pilot program description. So let's start with the history of our guardianship assistance here at UCH. The guardianship process began in 2018 because we were seeing an increasing patient population with a need for guardian and a limited ability for our APS or Adult Protective Services agencies to take on that. And so who needs a guardian? This comes from our statute, pursuant when an adult who is unable to effectively receive or evaluate information or both manage decisions to such an extent that the individual lacks the ability to satisfy the essential requirements for safety or self-care, even with the appropriate and reasonably available technological assistance. So that is our formal legal what we have to follow in the state of Colorado. Some cases within the hospital in which guardianship has been pursued for us, and this is unique to UC Health, is a facility. We get facilities refusal to take a patient on without a guardian. A lot of times it's because they might be an elopement risk. And so facilities, because of the risk to them for liability, they're hesitant to take them without a guardian. Also, no family or loved ones who can serve as a medical decision maker for the patient. And often folks who have progressed into a significant dementia with behavioral disturbance and patient not wanting to go to the facility. And in this next slide, I'm going to turn this over to Emily McDonnell, who will talk about our guardianship process here. Emily?
Hi. So as Katie talked about, while those are some of the biggest reasons that guardianship has been pursued here at UCH, guardianship can often remain a gray area for various cases that we're trying to constantly navigate and evaluate. One of the biggest considerations in guardianship is recognizing the gravity of this decision and working towards first valuing a patient's autonomy and the least restrictive means available. So often this means continuing to evaluate all alternatives, including avoiding guardianship. Throughout this presentation, I'll discuss some of the ways that we have done this, making sure that all options are being considered. The exploration of guardianship is truly an ethical consideration, as we highly value individualism and autonomy here in the United States. Therefore, in considering taking away someone's rights, there are many ethical implications and considerations that come into play. While guardianship is a court proceeding, so therefore the ultimate decision is made by a judge, it's really important that we present a case to the courts that we have thoroughly thought through and examined. So I'm going to talk through some of the scenarios that we have faced here at the hospital and the ways that we were trying to navigate discussions of guardianship, ensuring that—
Emily, can I interrupt for just a moment? We can't see your slides.
So
David, can we?
I'm not sure. It says that I'm sharing.
You may have to stop share and then restart share again.
Yeah, stop sharing.
Okay, and then
reshare and go back to your slide that you need to.
Gotcha.
You're at the, there you go, and then just jump to the slide you want.
Is it sharing? Because I can't see anything now.
No, it is sharing, but you're at the last slide and it's black.
Okay.
There we go.
Okay.
There we go.
There we go. Okay.
Okay, thank you.
Yeah, thank you. That's okay. So I'm going to talk about some of the scenarios that we faced here at the hospital and some of the ways that we're trying to navigate discussions around guardianship, ensuring that we're doing our due diligence and honoring patients' autonomy. So I also want to recognize that I'm specifically focusing on guardianship as it relates to discharge planning within the hospital setting, and recognizing that there are many other factors that go into guardianship determination for individuals in the community. So within the hospital setting, sometimes there's this thought that guardianship is this cure-all for patients. The hospital setting is focused on safe discharge planning, and rightfully so, how to get patients safely out of the hospital. And while this is an important focus, within this we can sometimes lose sight of what it truly means when we're stating that a patient needs a guardian. So sometimes very early on in a patient's stay, guardianship is recommended in the medical chart, even if this might not always be indicated or appropriate. We've seen this especially come up for readmitted patients or when patients are refusing our recommended discharge plans. And one of the first steps within this process is exploring a patient's capacity and their overall understanding of the medical recommendations and whether they still have the right to make poor decisions and choose to return to their prior living conditions. And while we might not deem this as a safe discharge plan, we have to first value a patient's autonomy to make those decisions for themselves. If we have determined that a patient no longer has capacity, it's really important to ethically examine and evaluate why we're discussing guardianship for a patient and what other creative solutions that we can first explore or rule out prior to pursuing guardianship. And while it's not ideal, especially within the acute medical setting, this can often take a lot of time to accomplish and kind of suss out. So I think it's really important that obviously in the acute medical setting that we expedite these processes, but we have to make sure that we're taking considerable effort as we're ruling in or ruling out the need for guardianship. I think also it's really important to understand the role of guardians for patients. So guardians are instructed by the courts to listen to the ward's wishes to the best of their ability, and therefore they work really hard to align with the patient's goals. While they're the ultimate decision makers, they are asked to consult with their wards and come to a solution that is most aligned with the patient's expressed goals and in their best interest. So a guardian cannot just automatically force a patient to do what we're recommending. So I think we need to take that into consideration as we're navigating our discharge planning as well. This also frequently, guardianship discussions comes up a lot with behaviorally challenging patients, especially as if patients are refusing cares or medications. It's important first to consider a patient's reasons behind these refusals. But if they are unable to make their own decisions, even with a guardian appointed, they cannot force them to participate in their care or to take medications. But instead, as I mentioned, they work really hard to align with the patient to better understand what are the biggest reasons for not wanting these cares and medications, and work towards developing ways to honor these requests and considering what's in the best interest of the patient. So sometimes we've even in the past had guardians that have been appointed to help patients make comfort-focused treatment decisions, ensuring that the patient's wishes are honored in the ways that we can best come to understand them. At the end of the day, while a guardian does have the authority to make decisions or sign a patient into a facility, as I mentioned previously, it's really important that they're aligning with the patient's goals and wishes. Psychiatric disorders or even intellectual disabilities are also conditions in which patients guardianship is discussed for patients. So in order to determine if a guardian is needed for someone with a psychiatric disorder, intellectual or developmental disability, we need to clearly establish that their disability directly impacts their ability to make decisions for themselves and severely impacts their ability to care for themselves. So for example, within this, a person can be psychotic and still be capable of making decisions for their day-to-day care and well-being, and can even make bad decisions around this. So we need to carefully build a case around their capacity that they cannot care for themselves. An important note, I think, especially for psychiatric considerations, is that guardians cannot agree to mental health treatment for an individual. The mental health court orders are an entirely separate court process. So if this is something that we think that guardians can do, it's not, so we have to go back to the drawing board to figure out our best plan of care for a patient. And as Katie mentioned before, patients with dementia are also highly talked about for guardianship need, but recognizing that not all patients with dementia are going to need a guardian. So we have to first explore whether their progression or whether their dementia has progressed to the point that they're no longer able to make their own decisions and no longer have capacity. And this is done through capacity evaluations, but it's sometimes also helpful to have additional cognitive testing. And here we do slums or like an Allen to lend additional insight to the providers when they're completing their capacity evaluations. When it is determined that a patient with dementia does not have capacity, some of the largest considerations as we're looking at potential guardianship need is whether a patient is willing to go to a facility or if they're a potential elopement risk requiring a secure placement. So as Katie touched on, sometimes when secure units are needed or patients are an elopement risk, guardianship may be warranted depending on facility recommendations because this is such a restrictive environment. With that being said though, that doesn't always mean that a patient needs a guardian. Sometimes with involved family members, documented MD POAs, or sometimes even a medical proxy, depending on the situation, can be enough to get a patient safely placed without guardianship. Part of the process here at UCH is exploring all of these possibilities for placement prior to considering guardianship. But if facilities are remaining hesitant to take on a patient, or a patient doesn't have any sort of documented decision maker, whether that's a proxy or an MDPOA, this is often when guardianship needs to be explored. So based on all of this, you can see that there are many considerations that come into play when considering guardianship. And this is often why it is such a prolonged process within the hospital setting, as it's not a decision that can be made overnight or can be rushed. So within this process, we rely heavily on the medical providers to continually assess an individual's ability to make their own decision. But I think it's really important also to recognize the team approach here at the hospital. So at UC Health, we're expanding our guardianship process system-wide to include a more formalized interdisciplinary team meeting that we're exploring whether guardianship is or is not indicated for a patient at a particular time. So members include medical providers, social work, ethics, psychiatry, therapy, and any other staff members that have been highly involved in a patient's care. We present the case and utilize this platform to discuss capacity, any formalized cognitive testing, including neuropsych testing if available, and placement considerations. The cognitive and neuropsych testing just provides a deeper understanding of a patient's impairments. And while no tests alone obviously can determine if a patient needs a guardian, they're just helpful tools that we're starting to more commonly utilize for patients as we're evaluating a guardianship need. Katie, if you could change the slide. Thank you. So as I mentioned throughout this presentation, guardianship should always be considered as a last resort. Even if a patient's impairments can justify guardianship, we need to really make sure that we're first exploring like all discharge options. And some of that includes whether a patient has an MDPOA. So if patients have an MDPOA, it's really important that we try our best to honor that decision maker when getting a patient placed. So usually that opens the door for us to avoid guardianship. Proxy is also a possibility, depending on facility comfort level and agreeableness of a patient. Proxy can often be used for placement purposes. As I touched on, some of the cases in which it's most needed for a guardian to be appointed is when a patient doesn't.
Slideshow. Sorry.
Cases in which a guardian is most needed is when there's no sort of MDPOA or proxy that can serve as a surrogate decision maker for a patient. Other considerations, as opposed to guardianship, is financial conservatorship or payeship. So if the primary barrier to placement is related to a patient's finances, conservatorship should be the route that's explored first, because it's possible for someone to just not be able to manage their finances, but not necessarily need a guardian for global decision making. Limited guardianship is also something that should be explored before unlimited guardianship. So limited guardianship can be appointed for decision making related to only medical, only residential, or only financial. So it's possible to also do a combination of those, but it should be explored if a patient just has impairments in one of those realms. Emergency guardianship is also a possibility, but it really should be considered as the last resort, because it should be utilized only in the likelihood of substantial harm to a patient. That's per the Colorado statute. So therefore, it's not as widely utilized, because sometimes within the hospital setting, patients are considered to be in a safe place. Emergency guardianship is possible to explore, though, because it is time limited. It's only a 60-day appointment and then needs to be reevaluated. So at that follow-up court date, and after 60 days of appointment, it's determined whether to terminate the emergency order if a patient no longer needs a guardian, or pursuing permanent guardianship at that time. So within all this, I think it's really just important that we're constantly looking to figure out why a patient needs a guardian, and if it's really, we're at that point where guardianship is indicated, but recognizing that it really should be the last resort for our patients. So as I've discussed, if it is indicated for a patient, we're turning first to family members that might be able to serve in this role. But as Sophia will talk about, there also are, the Office of Public Guardianship has started, and we are using them as well if patients don't have any family that can serve in that role. And so it's a really exciting program that Sophia will talk about, because there has just been a gap in Colorado as far as available community resources for guardianship. So I will let Sophia take it from here.
Okay, thank you, Katie and Emily. I'm going to share my screen. Hopefully it works, and it does work, but it's not on the slide I want. Let's see. All right. All right, thank you. Okay, hopefully everyone's good and can see my screen. Okay. So, thank you. Yes, I'm with the Colorado Office of Public Guardianship. Our office started not too long ago. I'm going to try and get my screen to jump to the next slide. Oh, I see a, sorry guys, I'm sure. Let me try that again. Okay, let's try that again. Sorry. It's not letting me. Okay, this is what I'm going to do. We're just going to look at it like this. Sorry. Okay, so Office of Public Guardianship, we were created a long time ago in statute with the General Assembly, but did not get any funding until October, well, actually July of 2019. I started as the director in October of 2019. And prior to that, I was a public guardian and also legal counsel with the Nebraska Office of Public Guardian. One of the main things that I am tasked with, besides starting this office and starting to serve clients, is also data gathering to create a report that's due to the General Assembly by January 1 of 2023. And that report, I don't go into too much detail in this presentation, but at the end of the slide, you'll have my contact information if you have questions or want more information. But this report is to basically give information to the General Assembly that says this is the need for public guardianship services across the state of Colorado. So we're trying to be creative in gathering this information throughout the state, because as I will talk about, our pilot project right now is limited to Denver County or the 2nd Judicial District. My hope, obviously, is that we expand statewide, and whether that happens with a few counties at a time or all of the rest of the counties in the next couple of years, I don't know that yet, but I'm very excited to have that opportunity. So our office launched on April 30th of this year, yes, during the pandemic, which was very challenging, but we still managed to do it and get clients going. And so we are now serving 22 clients, and we have several that are still in the court process that we haven't been appointed to yet. The makeup of our office is myself, a staff assistant, And then we have 4 public guardians. And our goal is to have each public guardian to have about 20 clients each, which is in line with the national best practice standards. To kind of piggyback, of course, on what Katie and Emily were talking about, what can we do as a public guardian? So it is a court process. Our office has to be nominated. We have to be able to serve this client, have the capacity, and have the statutory eligibility requirements for our program, which I touch on here in the next slide, I think. And the judge has to determine first in this court process, does this person need a guardian? So all those things that Katie and Emily were talking about, do they have capacity? If they have a certain diagnosis, does that actually impact their decision making? Are they unable to make decisions for themselves for that best treatment and those things? The judge first has to make that determination. Then if the judge determines that yes, this person lacks capacity and needs a guardian, then that's kind of the step 2, and that's when they appoint a guardian or us. So within that court appointment, the judge signs an order, and the order can be specific or not very specific as to what a guardian, what decision authority they have. Usually, typically what we see are unlimited guardianships, like Emily mentioned. That basically leaves the door open for a guardian to make any kind of personal decision related to that client. Any financial decisions, that's another court process, the conservatorship, which Emily mentioned. So these are some of the examples of the things that a guardian can make decisions over. It can be housing placement. Of course, it's to assist in obtaining benefits or maintaining benefits, medical care, dental care, eye care, those types of decisions. I'll talk a little bit about the ethics and standards that we follow, but always if the client has capacity for it, we delegate some decision making to that client. It's not just about we, the guardian, just making all the decisions and never talking to the client. We also focus on least restrictive services and person-centered planning, which I'm sure you've heard those terms before. As Emily was saying, we want to look at things least restrictively and respects the person's autonomy. So even if they have a guardian, and a guardian is there to make certain decisions, we still need to be working with our client and saying, what is it that you want? Again, you have to remember, we're talking about all kinds of clients. So some clients still may need a guardian for a certain purpose, but still have capacity to make other decisions and do other things. So it's going to always depend on your person, on that individual and what they're capable of doing. So we always want to work with them. We always want to know, what do you want? What are your goals? What are your preferences? And then as a guardian, we should be working within those goals, preferences, wishes to be making the final decision for our person. And then I was just going to make a note, our office, we serve just the person, just the guardianship. So we don't do any of the financial or conservator type work for our clients. So a little bit about our program. To be eligible, they have to be a resident of Denver County. That has an asterisk because I try to also look at, is someone placed elsewhere but had a nexus to Denver County and wants to be moved back to Denver County or something like that. So I look at a nexus as related to Denver County as well, to try and open it up a little bit more. They have to be an adult 21 years and older, indigent, and we follow the federal poverty guidelines for determining indigency. They have to be incapacitated. At this point in time, we don't limit the population that we serve. So our clients may have an intellectual or developmental disability, dementia related, so schizophrenia, they may have significant mental health issues. and which usually coincide with a significant substance abuse issue as well. So those are all things that can cause someone to be incapacitated and unable to make those medical decisions. And so we serve anyone with any type of incapacity related to that. And like Emily mentioned, our office is last resort in terms of the clients can't have any responsible family or friends that are available or appropriate to serve as guardian. So typically, obviously we have some clients that literally have no one else. The hospital has tried to locate family, locate friends, and there's no one else. Then we can obviously serve that person. We do have cases where there are some family members, but family members may have their own inabilities to be able to be guardian for an individual. And so we just have to make sure that we've explored all family and friends and made sure that they are not available or able to serve before we can be nominated to serve a client. And then one small kind of other criteria is that the client can't be subject to an Adult Protective Services guardianship petition. And that is because for Denver County, their APS is pretty strong and can serve as guardian in some instances. That's not the case across the state. Other counties don't necessarily do that. But I think basically the General Assembly didn't want us serving the same population as APS. So APS has their criteria. Often they refer to our office when someone doesn't meet their guardianship criteria. And then talking about ethics and kind of how our office works, and I like to think that our office is the kind of the model of how guardians, all guardians should be, but we follow the National Guardianship Association standards of practice. They have standards for agency and programs providing guardianship service. They have ethical principles, and then they have basic standards of practice. And as I had already mentioned, it's all person-centered, least restrictive. We're not there to take over someone's life. We're there to help them be as successful and autonomous as possible. And there is also, guardians can become nationally certified, and then a master guardian, I believe, are the two levels through the Center for Guardianship Certification. And myself and all of my guardians are working on getting that first master's level certification. But you can go to the National Guardianship Association and download all of these things. I included the ethical principles in this slide so that you can get an idea of what we do and how we look at our clients and our cases. Number one is treat the person with dignity. Again, it's, this is their life. You can make some decisions for them, but it's affecting them and their day to day. So we treat them with respect and dignity and talk with them just like we would anyone else. We involve the person to the greatest extent possible in all decision making. So again, someone needs to be discharged from a hospital. Okay, what are the options? What are the facilities? My guardians will go out. Now that it's COVID, it's a little more difficult to do that, but they'll go out, look at the facility, interview, and talk with the client. Typically, the client's not able to go out and see the facility beforehand, but our guardian does that, may take pictures, take it back to the client, and say, these are the pros, these are the cons, what do you think? So we want to include them as much as they're able. And then again, we are always looking at options that are least restrictive. We want them to be as autonomous as possible. And then we do advocate, we identify and advocate for a person's goals, needs, and preferences. We maximize the self-reliance and independence of the person. One thing that is that we do, that all guardians should do, is keep the client's information confidential. Even if you have family members that are involved, sometimes when we have to be involved, it's situations where maybe family is estranged. Family doesn't get along. that your clients burned their bridges and the family just really doesn't want anything to do with them, yet they want to know. They want to still kind of be, know, you know, where they're living, can we visit, things like that. So you just have to be real careful that you're not sharing information with family or anyone else that your client doesn't want you sharing. We avoid conflicts of interest and self-dealing. That is just, you know, we don't take things from clients, we don't borrow things from clients, things like that. Obviously, we comply with all laws and court orders. We don't manage financial matters. And for the NGA, they use Guardian to represent all fiduciaries, which could be a conservator that handles the financial matters. And we respect the money and property being managed, that it belongs to the person or our client. How do we do this? We do a lot of things with our clients to determine their wishes, determine their goals. And we see our clients every month at least. And we interact with medical providers and their care team as well, at least on a monthly basis. Usually it's more than that. But we have an internal document, an individualized guardianship plan that we have for each of our clients that we update monthly as we meet with them to make sure that appropriate services are in place, that we're working towards their goals and things like that. Referral and ethical considerations for our office, which I think also Emily talked about as well, was the incapacity. Just because someone is incapacitated, does that mean they can't make any decisions? Does that mean they only can't make certain decisions? If that's the case, then, you know, maybe a limited guardianship is appropriate. Are there other ways? So when a case comes into us asking if we can serve, I'm looking at all of the incapacity information. I'm looking at neuropsych evals. I'm looking at assessments, slums, and all those things. And I'm looking at any sort of consults that make it very clear to me that yes, this person is incapacitated. I won't take a case if it's not, I'm not the judge, so it's different than me saying, yes, I'll accept a case, but I need to have that evidence that someone needs a guardian, that they're incapacitated, because to me, as Emily mentioned, it's a very, very, it's a fundamental right that we all have to be our own person and make decisions for ourselves. So when you put a guardian in place, you're taking a lot of those rights away. So for me, it's a very serious thing that I look at. I don't want a guardianship on someone who doesn't need a guardianship. Same as I kind of talked about with the family and friends earlier, I don't necessarily make the decision that someone is appropriate or not appropriate for guardianship, but when I look at referrals, I am looking at all of the information that nurses may have put in, APS may have put in about family. We reach out to family if it's not clear from the referral, but there have been times that maybe someone is willing to serve, but maybe they weren't appropriate to serve. We don't make that ultimate decision, it's the judge, but I still look at that because I'm looking at this. We want family to serve a client before us, before a stranger, right? So that's another thing that we think about when we're going to serve a client, whether we're going to take that case or not. And these are all the things I kind of already mentioned about how we try to use best practices and the ethics that we follow, and what do we do for our client, and how do we make decisions, and how do we include them. As Emily mentioned, there are limitations to guardianship, and this is the hardest part, I almost think, of being a guardian, because you're trying to respect another individual. And so, as an example, Emily had said, we can't force someone to do something. We can make a decision, but we can't force them to go along with the decision. So that's because our clients have free will, right? They have the ability to refuse. And that's really difficult for us because sometimes we know someone needs a service or they need something, but we know they're going to refuse, they're going to walk out. Or we try it and they refuse and they walk out. What do we do? You know, it's difficult in thinking what is it that they want, but what is good for them, right? There's always that balance. Again, as Emily mentioned, we can't force meds. We can't force a mental one hold. As guardians, those are two separate court processes. We can assist in the process, but we can't pick up the phone and say, hey, police, come get our person and put them in the regional center. We can't do that. One thing that is difficult too, and especially thinking about ethics, are our clients have limited funds. They're usually on Social Security benefits of some type, Medicaid, that's usually all they have. And also the community inefficiencies that we see, you know, lack of housing, lack of availability of appropriate programs. And so sometimes we want the best for our clients, but we have to live in this reality of what's available, what can the client afford? Because as a guardian, you don't take on that person's, you know, financial interests. So we don't have like a fund of money that we can use for our clients. It's what can we do within that client's available resources, which is often difficult for us. One of my guardians, we were talking, I think yesterday, and you know, the question is, well, what do we do? Because I think they need this. Well, but they can't go to that certain type of placement. The issue was a placement issue. But it's like, but where she is right now, she's safe, she's getting treated, she's cared for. It's more restrictive than we like, and we're looking for least restrictive, but the reality is it's going to be hard to place her because she has significant mental health issues. So there's a lot of ethical considerations that we go through every day, just trying to serve our client, making sure that they're safe and you know, being again as autonomous as possible. So here's my contact information. I'm sure you'll be able to get it some other way as well. That's the office phone, but there's my email address if you'd like to email me directly. And our website has a lot of information on how to refer to our office and other information about our requirements.
Thank you very much, all three of you, for a compelling presentation. Sophia and Emily and Katie, really appreciate that. And there are a variety of questions, and I will start with the first one, maybe for Emily, really for any of you. Basically, who assesses decisional capacity?
In the hospital setting, it's the medical team, or psychiatry does, but more often at Metro, at our campus, it is the medical team that is assessing for capacity.
Okay, and I would guess that's different at different sites, or different hospitals, but yeah, that's what we do here?
Yeah, some, it sounds like use psychiatry primarily as their consult for capacity assessments, but yeah, here it's a combination. Sometimes psychiatry does it, but primarily the primary medical team does our capacity assessments.
Okay, so psychiatry doesn't have to be the ones doing it. So are guardians paid? For anyone?
I'll help answer that.
Yeah.
Guardians can be reimbursed from the client's estate, but that requires permission from the court. In my humble opinion, we're really behind in looking at guardianship as a service for people. And I think that's one of the reasons why people don't want to be guardians, is because it does take a lot of time and effort, and typically you're not really paid for it.
And I'll just add to that. One of the things that we do here, Julie, is, again, as Emily said, we really want to try to get family members, if they can become the guardian. What we have found is it is a complicated process. So even if we have families who are willing to do that, often they need help navigating. And so we have, we work with a legal firm who their legal assistants can help the family work through the paperwork and file it. And Emily, you pipe in here if there's something more you want to add. If there isn't family, and before the Office of Public Guardianship was in place, we did vet a couple of guardianship agencies, and we have, when there's nobody else, we have do contracts with those agencies for a time limited where we will support and pay those guardians for their services. Did I miss anything, Emily, you want to add?
No, I think, and that's to Sophia's point, I think a lot of the time it does end up being unpaid sometimes, because we do time limited, and recognizing that guardianship is appointed for the likely for the remainder of the person's life. And so there is a long time that someone might be serving as a guardian, so might not be funded during that entirety.
Thank you. So, Katie, you mentioned that that there's an increasing number of people needing guardians, whatever that's about in our society, and that the focus of a lot of this has been on placement, guardians making decisions about placement. What are some of the other kinds of issues or topics or ways that guardians are used in the hospital setting?
So I would say that, just to clarify, we have seen an increasing request to get guardianships, but to Emily's point in her presentation, it's sort of the panacea. Everybody needs a guardian, and everybody doesn't. And that's why, because as Sophia said, this is such a huge thing to take away a person's rights. And so what we have found in our process, and one of the reasons that Emily and I developed this guardianship committee, if you will, system-wide, is so that we're really looking and being thoughtful and talking through with ethics, with other people on the treatment team, to really determine if guardianship is necessary. So while I say, yes, we're seeing an increasing need, I think it's more that there is an increasing idea that guardianship is the be-all end-all answer, and we really need to we have an opportunity to do a lot of education with our providers and stakeholders around that. So does that make sense? I'm not sure if I answered your question totally, but.
Yes, well, yeah, I just wondered what other kinds of things they're involved in or decisions that they're making. But with that, and maybe this is a good segue into another question, which is, does the guardian become the proxy or the MDPOA? Or is that the question behind the idea that a guardian's a panacea?
Within our experience, it does say in the court orders whether they take on the MDPOA. So I've seen in court orders that they do say that any previous MDPOA would not be honored anymore, and so the guardian would be taking on that role, but it has to be specifically, and Sophia can speak more to this, but it has to be specifically addressed in the orders.
Okay. Another question, how does a public guardian differ from a guardian ad litem?
Yes, so a guardian ad litem is a different specific legal role within the court system. So as an example, they can be appointed by the court for the investigation and determining best interests for an individual. So that's very separate. It gets confused all the time. So I totally understand that question. So that person is there just for that role. They're not there to make decisions or anything like that. They basically report to the court and say, this is what the client wants. This is what I think they need in their best interest. So a lot of times those are conflicting, or they can be. So that's what a GAL does. A public guardian, we're actually appointed as the guardian who's going to be making legal decisions on behalf of that client once the court appoints us.
Okay, thank you. So Sophia, who becomes the conservator if the Office of Public Guardianship becomes the guardian?
So it depends. Sometimes an individual doesn't necessarily need a conservator. So we're able to assist with getting documents for financial reasons to get a rep payee for an individual, or to obtain benefits for an individual. We don't have a bank account to pay bills or things like that. That's when they need a conservator. So what we do is right now we contract with Colorado Fund for People with Disabilities to be rep payee for clients if the facility or if no one else can be rep payee. If someone needs a conservator, there's different avenues. There's the public administrator, which is there's one for every kind of judicial district. It could be another fiduciary agency. As an example, there's Basor and Christian. So it could be typically fiduciaries, financial matters are much more monitored here in Colorado. And so primarily you're going to go with a professional, not a layperson as a conservator. I don't know if that helps.
Yeah, it does. Thank you. I hope it helps the person who asked the question. If not, ask again. So thank you. So who monitors the guardian? Sophia, you mentioned that they are aligning with patients' best interests. Who monitors that?
Right. So typically the court monitors a client and their guardian. So a guardian has to file annual reports. If there's ever something that comes up that the guardian may want court assistance, the guardian can also contact the court for a hearing to request kind of guidance. But typically it's those annual reports that we provide to the court that says this is where our client is, if they've had to move throughout the year, why did they have to move, what medications are they on. They're confidential, they're not open to the public, these documents. That's typically the way a guardian is kind of has any oversight. Through the Office of Public Guardian, I'm hoping to implement more oversight for guardians, not just for us, but private guardians as well, because the court only has, so much time to devote to overseeing, and sometimes things slip through the cracks. So.
Okay, so really for all of you, the question, am I understanding that guardians are volunteers? How do you recruit them, train, and supervise them?
Yeah, so right now, Colorado, we don't have a way to really oversee guardians. There really isn't training for guardians. There really isn't any, you have to pass a background check, and they have like videos available for you if you want to review them to become guardian. That's another thing that I'm trying to maybe change with other entities as well, that we kind of have a set training program so that all guardians are certified or at least go through the same type of training. For my guardians, I can only speak to my staff. They went through months of training. We did the NGA stuff based on my experience in Nebraska. We trained a lot on all the NGA ethics and things like that. And that's also why we're going through the national certification to kind of enhance and show that there's more that we can do as guardians to kind of be held accountable. But other than that national certification, there isn't another way that someone can really check and look up guardians to see if they're appropriate or still allowed to be guardians.
Okay. For all of you, in April 2020, the Office of Professional Guardianship site stated 5,800 Coloradans needed this service. Has that need increased? Do we know?
That's a good question. I don't know that yet. We're in the process of gathering that type of data. I hate to say that, but I think COVID kind of threw a wrench in some of that, trying to, yeah, because for us, you know, we could become guardian, but then we couldn't facilitate moving someone, say, from a hospital and discharge. And so also our courts were closed for a time for permanent guardianship hearings. So it's kind of hard right now, I think, to assess, but that's certainly information that I am tasked with getting.
Okay. Thanks. And another question is, do ethics committees get involved in every case when guardianship is sought?
So I can speak to that from starting this process. In the beginning, not so much, but as we have evolved with this process and really have recognized the gravity of what we're proposing to do for a patient and placing them with the guardian, this new process that we've kind of honed in on is that we do ask that a member of ethics is a part of the discussion when we talk about a guardianship, because I think we feel like it's really important to get that lens, because the whole autonomy piece of, you know, are we doing the right thing and does this person really need this? And I think personally it's been incredibly helpful to have ethics. So it's always my recommendation to bring them in.
Okay.
So.
Thanks. Can a guardian ever sign someone into outpatient mental health treatment?
No.
No?
We can recommend it. A guardian can recommend it. It just goes to what Sophia was talking about, that, you know, we can encourage, you can advocate for that, but at the end of the day, they have free will. And especially with psych, you can't force them into psych treatment. That's a whole separate court process, as Emily said.
Okay. Given the situation with the courts, what happens to the client in the interim of trying to get in to see the courts?
Well, if they're here at the hospital, they are here at the hospital. They'll stay at the hospital. A lot of the time, well, sometimes for our patients, there's a MD proxy that is serving in the role of making any medical decisions. More often, though, a lot of our patients are medically stable, so there's not really a need for anybody to be making medical decisions for them. So they kind of are just here awaiting appointment of a guardian, so that we can figure out the next steps for them.
Great, thanks. One last question that may be too big to answer in a minute or so, but are there limitations for undocumented individuals to try and obtain guardianship for their family member?
No.
That was quick.
Yeah, no, done. No, there aren't citizenship requirements or anything like that when it comes to getting a guardianship. The only consideration I would mention is depending on the client. If they're undocumented, there may be issues with getting them services.
Okay. Sounds good. Thank you. I'm aware of time and we need to stop, but I want to thank all of you. Really compelling issue and a very compelling presentation. Appreciate it very, very much. Thanks for your work, and thank you, all of you, for your questions and your participation. Really appreciate it. Best of holidays to everyone, and we will see you in the new year in January. Thank you. Bye-bye.
Thank you.
Thank you.